In an important judgment today in the Suo Motu case of COVID-19 issues in the Supreme Court, a bench of Justices D.Y. Chandrachud, L. Nageshwara Rao and Ravindra Bhatt has noted that the liberalized vaccination policy adopted by the central government is arbitrary and irrational with regard to the vaccination policy for the age groups of 18 to 44 and 45 and upwards. The top court has noted that for 45 and up, it's from the central government, whereas for 18 to 44, these are paid vaccinations by the state governments or by the private hospitals. The court has also stated that the state governments who have said that there be free vaccinations in their particular states for COVID-19 needs to file an affidavit in the top court putting that in record. Supreme Court has also criticized the liberalized vaccination policy by stating that it does not take into account people with comorbidities or disabilities. Since central government had vehemently argued that the Supreme Court should not venture into this domain of policy since it's an executive-specific domain, the Supreme Court today has clarified that it does not intend to breach the executive domain. However, it will continue to exercise its jurisdiction to test the policy on the touchstone of reasonableness and arbitrariness. Very importantly, today the Supreme Court has also recognized the presence of digital divide in this country and has noted that a universal vaccination policy can never be successful in this country if it solely depends on a digital platform like the CoWIN platform. The court has noted that there are serious issues with bandwidth and digital connectivity which impedes the penetration of internet in the rural areas of India and thus widens the digital divide. Therefore, the court has noted that the digital divide could have serious implications for the right to equality and right to health as enshrined under Articles 14 and 21 of the Indian Constitution. The court has thus asked the central government to clarify whether specific daily quotas may be introduced for on-site registration at each center or specific centers, whether on-site registration with self-attestation of age to ensure widespread vaccination can be provided, conduct a disability audit for the CoWIN website and other IT applications like Arogya Setu app to ensure that they are accessible to persons with disabilities. Supreme Court today has also asked the central government to provide entire purchase history details of all the vaccines in the country, which is Covishield, Covaxin and even Sputnik 5. The court has ordered that the data should clarify the dates of all the procurement orders placed by the central government for all three vaccines, the quantity of vaccines ordered as on each date, and the projected date of supply. Regarding placing the COVID-19 vaccination policy before the Supreme Court, has directed the Union of India to provide an affidavit which it shall ensure that copies of all the relevant documents and file notings reflecting its thinking and culminating in the vaccination policy are also annexed on the vaccination policy. The affidavit in this regard needs to be placed before the top court within 2 weeks, and the case will now be taken up next on June 30th, 2021. A Supreme Court bench led by Justice L. Nageshwara Rao today heard a plea by Madras Association challenging Sections 12 and 13 of the Tribunal Reforms Rationalization and Conditions of Service Ordinance 2021 and Sections 184 and 186 Clause 2 of the Finance Act 2017 as amended. Senior Advocate Arvind Dattar, appearing for the Madras Bar Association, submitted that the amended provisions challenged in the petition is in contravention to the basic structure of the Constitution. Senior Advocate Dattar also raised the point of independence of judiciary. However, when Attorney General K.K. Venugopal made his submissions on behalf of Union of India, he stated that independence of judiciary as a concept does not find mention in the Constitution of India and that there are only Supreme Court judgments regarding it. However, Justices Hemant Gupta and Ravindra Bhatt differed from the Attorney General and stated that there is a link between the basic structure doctrine and Article 14 of the Constitution, and also drew the attention of the Attorney General towards the 2010 judgment of the Supreme Court, which is the Union of India versus R. Gandhi, President of the Madras Bar Association. Supreme Court in this case is also delving into the arena of impermissible legislative overruling and permissible legislative overruling, and the petitioner's lawyer has been asked to highlight this particular point. The hearing in this case is slated to continue tomorrow as well at 12 p.m. and will continue for an hour more since the Attorney General in this case sought some more time to wrap up his submissions. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share barandbench.com.